Is working from home a right or a privilege in 2026? This week we are joined by Antonino Meduri, Principal at AM Lawyers and Partners, to unpack where flexibility expectations and legal obligations begin. As hybrid policies continue to evolve, many employees believe remote work is now an entitlement. So where does the right to work from home really stop? Hi everyone, my name is Liz Punshon. I'm the Managing Director of People to People Recruitment Victoria. Welcome to our People to People Market Update. As businesses push for the return to in-person work and employees push back, the gap between perception and reality continues to widen. Recent data shows that 66% of 1,000 surveyed believe that working from home should be a right, yet 1 in 3 have had a request denied in the last 12 months. With expectations shifting rapidly, questions are emerging around what employees are actually entitled to and how flexibility can realistically extend, and where businesses may be exposing themselves to risk. To discuss this further, we're joined today by Antonino Meduri, Principal at AM Law and Partners. So welcome, Antonino.
Hi, Liz.
Thanks for joining us today. So to kick things off, please tell us a bit about yourself and AM Law and Partners.
Absolutely. Thank you for hosting me. So I'm an employment and work health and safety lawyer based in Sydney, and my practice AM Law and Partners advises employers across employment law, work health and safety, and related commercial disputes. And much of my work involves helping businesses navigating, employment and safety disputes, restructures, workplace investigations, and compliance challenges. And of course, a recurrent theme of the past few years has been a recurrent theme in the employment world generally, I would say, has been hybrid work.
Interesting. Yes. Well, thank you so much for joining us today. From a legal perspective, what are employees actually entitled to when it comes to flexible or remote work? And where would you say the right to work from home really stops?
Yes, so this is actually the biggest, I suppose, misunderstanding of all. So legally, in Australia, there is no generalized right to work from home. Entitlements, generally speaking, from an employment perspective, arise in 3 ways, either from contractual terms, so a contract will expressly either allow or confer a right to work from home, enterprise agreements or policies, if they incorporate flexibility, and in the case of policies, if they are incorporated in the contract. And then, and this is the big one, the statutory right to make a request for a flexible working arrangement. So since it's been a few years that the Fair Work Act now provides for a right for certain employees to make a request for a flexible working arrangement. The snapshot is that, again, certain employees can have the right to request flexible working arrangements, but they don't have the right to for the request to be granted, right? So drilling a bit more into this, because I guess is the main one. Employees who are pregnant, are the parents or have the responsibility for the care of a child who is of school age or younger, are a carer, have a disability, are 55 years old or older, and are experiencing family and domestic violence, and are caring or supporting an immediate family or household member who requires care or support because they're experiencing family and domestic violence. These employees are entitled to make a request for a flexible working arrangement. This flexible working arrangement can be working from home, which is the classic one, so changing the location of work, but it can also be, for example, changes in the hours of work, starting and finishing times, or changing in patterns of work, such as, for example, splitting shifts. Again, the entitlement is for these employees and these employees only to make a request for a flexible working arrangement. The employer then has 21 days to consider the request and consult with the employees. And then at the end of these 21 days, the employer must provide a response. The response can be a refusal, as long as the refusal is based on reasonable business grounds, which can be, for example, costs, or it is incompatible with the requirements of the request is incompatible with the requirements of the role. A very easy example would be a factory worker asking to work from home doesn't make sense, and so that's it really. This is where the legal boundary is. Certain employees have a right to ask for a flexible working arrangement, which may or may not cover working from home, but not a right to obtain it.
Right. Okay. Thank you for explaining that in so much detail. Do you think there's currently a disconnect between what employees believe they're entitled to and then what employers are legally required to provide? And where are you seeing the biggest misunderstandings?
Yes, absolutely. So look, many employees believe that hybrid work has become an acquired right post-COVID, essentially. Now, legally, this is generally not correct, because, as we said, it's only certain employees that have a right to ask for a flexible working arrangement, including work from home, and in any case, there is no right for such request to be granted. The biggest common misunderstandings normally are, assuming that an historical practice of allowing remote work has led to a permanent entitlement, believing that making a flexible work request must lead to an approval. In other words, the approval must happen as a matter of law. Also, believing that the right to make a request to work from home, for example, applies, generally speaking, to make a request for a flexible working arrangement applies to all employees, when in fact it's only, again, the ones that I specified. And then also treating policy statements such as, for example, employees may work from home as contractual guarantees. And then I would say another one is overlooking operational requirements. Certain employees, even who might be eligible to request to work from home, they make the request thinking that it should be granted, but they ignore the fact that the operational requirements of the business, and they become inflexible, and they say, it's out of my way, in the sense that I should be granted this request, or I'm going to the Fair Work Commission, without considering the fact that a business might genuinely be entitled to refuse the request, because as made, the request is simply not compatible with the business operations. And so I guess in one sentence, the disconnect is essentially, the fact that the workplace culture, particularly during and post-COVID, has evolved faster than the legal rights.
Right. Yeah, absolutely. And in terms of when businesses decide to tighten or formalize their work from home policies, where do they most commonly expose themselves to risk?
Yes. Look, the risk is as much in how the change is implemented as in what the policy says, right? So unilateral, I guess, key exposure points will be having a contract worded in such a way that either by itself or because of a combination with a policy poorly drafted, essentially provides for the employees a contractual right to work from home, and then the employer seeking to unilaterally reverse that right, which is not possible, because once something becomes a contractual right, then can only be varied by agreement. Another one is failure to consult. So if you have if you've had a work from home, say, free for all policy for the last 3 years, and then all of a sudden you say everybody back to the office, that may potentially be classified as a major workplace change under certain awards or enterprise agreement. And so in turn require or rather trigger certain consultation obligations. Then you also have inconsistent application, which can create, discrimination and adverse action risks. Then, I would say another risk area is poorly drafted policies and I will say probably operational guidance to managers. So, ambiguity around the discretion to refuse the request, the ambiguity about the process to follow, review mechanisms, and so on. All these things can create confusion in the business and lead to complaints. And then ignoring the classical one is just ignoring a request. So don't do anything for the statutory 21 days period, which entitles eligible employees to escalate the disputes to the Fair Work Commission, which can be costly because at the point, you might, for example, need external legal representation.
Right. Yep. So very important points there. And from your experience, what are some of the most common and most expensive mistakes that you're seeing businesses make when they're implementing or changing existing hybrid working models?
Costly mistakes are generally around, in my experience, four areas. One is treating policies casually, or policies and contracts casually. So you might have either because, as I mentioned before, the wording in a contract, a contract referring to a policy and incorporating the policy as part of the contract, and then the underlying policy is essentially containing a wording to the effect that employees' right to work from home, or to certain other flexible arrangements is unfettered. So it's simply a contractual right that is granted as opposed to something on which the employer maintains ultimate discretion. That's a problem because, as I said, it can be costly because it can lead to essentially at that point you need agreement to reverse that. Create failure to communicate with the workforce. So, having years of unrestricted, say, remote work, and then abruptly reversing such policies, which can create conflict. Inconsistent enforcement, I would say, is another one, because it can lead to, for example, discrimination claims and adverse action claims. And then also poor documentation. So, no records of consultation, no record of refusal reasons, no records of performance concerns associated with the refusal reasons. These are, keeping records is generally important because it can be, of course, very difficult to demonstrate that you followed the process properly afterwards. All of this is costly because it can go from, it can cause loss of morale in the workforce. It can cause attrition and disputes. Employees tend to take these things to the Fair Work Commission fairly easily. There is a really bringing an action to the Fair Work Commission is pretty easy. You don't have to go through the hurdles that you have to go through when you go to court, which again can be expensive for the business, and obviously, loss of productivity.
Right. Yeah, absolutely. And then looking forward, what does a legally sound and commercially realistic hybrid model look like in 2026? And what advice would you give businesses when it comes to finding the right balance with flexibility expectations without losing control?
Look, I will say that a defensible hybrid model will typically include clear alignment between contract and policies. So, a contract referring to a policy without incorporating it as a contractual entitlement, and then a policy being drafted in such a way that reserves the employer's discretion. Then, and of course, here I'm not referring to necessarily to flexible working arrangements which employees can request as a matter of law because of the because of the scheme under the Fair Work Act that I said before. I'm talking generally. The ensuring that you're, generally speaking, is a good practice to ensure the policies are not necessarily contractual, depending on the policy, but that they are not that they don't form part of your contract, and then that they are drafted in such a way to maintain the employer's discretion to change those policies. Then clearly defining eligibility frameworks and approval frameworks, and educating your management both at the operational level, but also of course at an HR level on those policies and on those guidelines. Documentation, so documenting the steps followed in consulting with the employee, clearly documenting the business rationale of why a request was refused, but also why a request was granted, so that you can defend yourself in case employers can defend themselves in case of claims for discrimination. And then complying with any consultation requirement which might apply either by way of statutory force or by way of major workplace change, in case the requirements under modern awards are triggered. And then I will say consistent application. In other words, make sure that there is no one size fits all, obviously, but making sure that as far as possible you are consistent in how you apply your policies.
Absolutely. Such good advice there. Thank you so much, Antonio, for joining us this afternoon. In terms of if anyone would like to connect with you, what is the best way to reach out to you from here?
I'll look, all my contact details are on our website, which is 𝗵-law.com.au. They can find address, email, phone number, everything.
Amazing. All right, great. Thank you again.
Thank you, Liz.
And that's all from us for this week. So thank you so much for joining us today. If you are looking to grow your career or build your teams, People to People Victoria and across our People to People group, we are here to help. So you can connect with our team on the details below. But yeah, thank you again for joining us today, and we'll see you next time.